Hi, this is Ifeoma Odolami, immigration attorney from the Odolami Law Firm in New Jersey. Our law firm serves clients in all 50 states. And today I have a great topic. And this topic is really going to be useful to a lot of people. And so if you find it useful, please like, share, and subscribe. And let me know that in the comment section that you're here with me. Let me know where you're tuning in from. So today, the topic of today is when applying for naturalization may cause you to lose your green card. Yes, it happens. Applying for naturalization could cause you to lose your green card, right? So naturalization, as you guys know, is the way a green card holder becomes a citizen, right? There's so many benefits to being a citizen. You can vote, you can file for your family members, your wife, your spouse, your married children, your parents, your siblings. You know, there's so many good things to naturalizing. You can, as I said, you can vote. That's the ultimate in having a voice in America, being able to make a decision regarding who's going to take charge of certain aspects of your life, right, in politics. So, as even though there are a lot of benefits to becoming a U.S. citizen, you want to make sure that applying for naturalization is not going to put you in deportation proceedings, right? So, um, hi everybody, thank you for joining me. I'm going to answer questions as soon as I finish. If we have some time, I'll answer some questions. And like I always say, if you have any questions, please put it on the comment section. I always come back to look at that, and I can use that for the topic of the next live. So to qualify to naturalize, you can get that. There are many, there are many things that you're supposed to, many criteria you're supposed to meet, but you can get your green card. Once you get your green card, you can qualify for naturalization either uh, um, after 3 years of getting your green card, in which case that means that you're married to a U.S. citizen and you're still married to them, or you qualify after 5 years of having your green card, which means you got it through either an employer or another family member or a spouse that you're no longer married to. So this is what we're going to talk about today, making sure that if you're applying for citizenship, you want to make sure that you're doing so safely, right? So thank you, Sasha, for joining in. Thank you, Timmy Tokwe, for joining in. So let's talk about that. So we're talking about the times that you should not file for naturalization. You want to know uh, whether you fall into this category, so that you don't put your green card in jeopardy. So let's talk about one. I'm going to talk about what's like 4 or 5 ways in which you can jeopardize your green card. The first one is if you got your green card through fraud or mistake, right? And the USCIS officers didn't catch on to it at that time, and then you apply for you apply to naturalize to become a U.S. citizen. They may at that point catch on to it, and that could actually get you put in deportation proceedings. And what is this mistake or fraud I'm talking about? So first of all, let's talk about mistake. And I'm talking from, experience. The clients I've had, mistake. There's a client I had who came into the United States. Her parent filed for her. So her parent filed for her as a single person over 21, right? Under the F1 category. So she was approved. Her priority date came. She was approved. But just before she went to the embassy to get her green card stamped so that she could come to the United States, she got married. Now, getting married put her in a whole different uh, uh, category, which would be the F3 category because now she's a married child of a US citizen. And the priority date of that category is it takes a long time. So when she got married, she moved to F3, but she didn't realize that. And I don't know whether she says that the US officers didn't ask her that, whether she was married, but typically they will ask you that, whether you were married before you leave the country. But she said they didn't ask her. But regardless, she came into the United States with her green card. 5 years later, she was excited to go file to become a US citizen. And during that process, she mentioned her husband. And then the investigation began like, okay, when were you married? And then they found out she was married before she came into the United States. And of course, that was a problem. So her naturalization application was denied. So after it was denied, she came to my office so that we could, figure out what happened. And then we figured out that was what happened. But luckily for her, she was not put in deportation proceedings. But it is possible that that act of being in the wrong category and getting a benefit that you were not supposed to get could have put her in deportation proceedings and could have led her to lose her green card. So let's talk about another way that you can get a green card that you're not entitled to. We're talking about those who are involved in a sham marriage. So they're involved in a sham marriage. They get through the interview process. They get a green card. Sometimes they even get through if maybe they had to do a removal of conditions, they get through it for somehow, somewhere, and then they come to the interview stage, to the naturalization stage. At that point, if the officer looks at the application again and sees signals or that indicate that that marriage was not a real marriage, they're likely going to yank that green card. Yep. So just because you were able to get through, or the person got through the interview stage and got their green card, doesn't mean that you have the green card for life if you apply for naturalization. Because if you've applied for naturalization, they get a chance to look at everything again. So in that situation, that may be a time when you might not want to apply to naturalize. Now, let's talk about another time when you can get, you're not lawfully admitted, is what it's called, is when you enter the United States under a fake name. And you get all these benefits of getting a green card without filing for a waiver, filing for forgiveness. And at some point, this information comes to light. That could jeopardize your green card. Now, another way to jeopardize your green card is if you obtained your green card as a single person, but you're actually married. I think we talked about that. Or you obtained your green card through marriage to one person, but you're married to another person. But you know that bigamy is against the law in the United States. It's not called polygamy, it's bigamy. If you're married to somebody and you marry somebody else, that's bigamy. So those are ways where you came in, got a green card through fraud, right, or misrepresentation. You were not entitled to get that green card, but you got the green card, and then you go to try to naturalize, and the U.S. officer goes back again to review your document. I've had clients come for consultations that by the time they give me a whole bunch of information, I look at them, I'm like, you're going to get into trouble if you naturalize, because I'm not sure what you did, but this looks really suspicious, right? So if you actually did something that's against the law, they're going to be looking at it, right? So another way that you can jeopardize your green card when you naturalize is lacking good moral character. So good moral character is, they define it as, we know it when we see it. Sometimes it's hard to define, right? But in terms of naturalization, USCIS looks 5 years prior to your filing to determine whether you exhibited good moral character at that period of time. Now, they tell you 5 years, but they really can look as far back as they wish. So there are certain things, there are certain actions that you commit, certain crimes that you commit that make you ineligible. You can never naturalize, such as murder, aggravated felonies, drug crimes, right? Those are the things that can never, ever allow you to become a U.S. citizen. Now, there's certain other crimes that could be, questionable. Crimes involving moral turpitude, you know, it kind of falls, somewhere along the line, and for that, you really want to talk to an attorney for them to do a proper immigration analysis on whatever it is to see if you applying for naturalization could endanger your green card. Now, other things that make you lack, that USCIS looks at as lacking good moral character. If you owe taxes, right? If you're not filing your taxes regularly, that's a problem. And even if you decide to file your taxes, like if you haven't filed taxes in 3 years and you go and file all your taxes just before you file for naturalization, that's still a problem, because it seems like you're filing your taxes just because you want to naturalize, and that's not having good moral character, right? Like I said, if you owe child support, whether it's child support with an order, whether the child is here in the United States or abroad, if you owe child support and you're not taking care of your children, that is a sign of, somebody who's lacking good moral character. Now, another thing that would make you suspicious or looked at as somebody who lacks good moral character is if you didn't register for selective service intentionally, that could be a problem. However, if you didn't know that you had to register, then that's a whole different, um, issue. Domestic violence is a problem, right? So those are the things you want to talk to an attorney. And if you have any criminal charges or any criminal background, you know that you're going to have to get the disposition, certified copy of the disposition. All right. So you want to make sure that if you have any criminal record, DUIs, having a DUI does not disqualify you, but you want to talk to an attorney to make sure that in your state it's not a problem, right? And now the third category, which a lot of people fall into, is when you don't satisfy the continuous presence and the physical presence requirement. So if you apply for your naturalization after having your green card for 5 years, you're required to be physically present in the United States for half of that time, at least 30 months. And if it's 36 months, you're applying for your naturalization because you've been married to a U.S. citizen and you're still married to the U.S. citizen for 3 years, right? Then you have to have been in the United States for at least 18 months. And if at any point in time you've been outside of the United States for more than 6 months in one trip, there's a presumption that you have abandoned your green card. There's a presumption. It's a rebuttable presumption, but it lies there. There is a presumption. And if you've been outside the United States for more than 1 year, you've pretty much broken that permanent residency requirement, right, for physical presence. And like for a lot of people during COVID, they were outside the country. They couldn't come back in for one reason or the other. And they were outside the country for more than a year. Unfortunately, there were no excuses made for those people. And if you fall into that category, you had to basically start from scratch again. So if you've not satisfied that physical presence requirement, you have to start again and from scratch. And so after 4 years and 1 day, you may file for naturalization again. I know that was really unfair over COVID, because I kind of felt that they had to have made some exceptions for that, but nope, I haven't heard of any exceptions made for that. And so let's see. Now, what are the other ways other things that you might do that may disqualify you and put your green card at risk when you apply for naturalization? For instance, if you're applying for naturalization because of marriage, and you applied after 3 years, and then but at that point you were no longer living with your spouse, that would be a problem when you go to naturalize for real, right? Or if you got your green card through an employer and you're required to work with that employer because they gave you your green card, but you didn't work with them, or you didn't work with them for the required amount of time, and you go to naturalize, that's the question that the officer is going to be asking you. So that's why it's important that if you decide to apply for naturalization, you really want to talk to a lawyer and make sure that it's going to be a straightforward naturalization application. Now, the fourth category of denials would be those who don't pass the civics test or the English test. So if you don't, they actually give you another chance to take that test. So I think 60 days from whenever you were, the previous test that you didn't make, you could go back for another test. And if you missed that, you don't, you don't pass that, then you have to reapply again. For some people, you know, it, the time when you can reapply really depends. If you had a criminal issue and maybe say you're on probation, you want to wait until 5 years from when your probation ends, and then you can apply for naturalization. So basically, what I'm saying is, don't assume that just because you have a green card, that becoming a U.S. citizen is going to be a piece of cake. That is like the greatest, honor that USCIS bestows on an immigrant, because now you're given the same rights as any other American, except you cannot run for you cannot be the president because you're not born here. But so you want to know that USCIS the officers are going to really look into to your application to make sure that you're somebody who is, has good moral character. They want to make sure you were lawfully admitted. They want to make sure that you complied with the USCIS rules with regards to physical presence, continuous presence, because especially with regards to the physical presence and continuous presence requirement, people think that they can live abroad, then come to the US for a short period of time and then go back, and continue, and then come back every year. As long as you come back every year, that's the room. As long as you come back every year, as long as you're here for 6 months every year, you're fine. Not really. There has to be indications that you actually reside here in the United States. So let's see. I think that's all I wanted to say for that. So let me reach out and see the questions. I know somebody asked me a question from Instagram. Let's see. I think Sasha said, how long do you take to send off to a VAWA case to USCIS? How long do you take to send off a VAWA case to USCIS? Now, how long does it take us to get the case ready? It really depends on the client. Some clients give us everything we need, boom, 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 and we're able to get it together and send out. Some clients it takes them a while to get the stuff we need. We don't like to file skeletal petitions, right? Unless there's a reason for it. And skeletal petitions is a petition where we put just the barest minimum, right? And then, send more out later on. But if we have a deadline, maybe there's an I-485 pending, and we want to make sure that we send the VAWA before the interview, because we're trying to move the VAWA case to the I-485 to the VAWA case, then we want to get that out as soon as possible. We've been known to file that within 2 weeks. However, if it's a regular VAWA case, VAWA has a lot of moving parts, so you really want to make sure our clients give us all the stuff we need. We have to do the declaration interview. We have to collect evidence of a bona fide relationship. If it's a marriage, we want to collect evidence of abuse. Sometimes we need to get letters from affidavits from people and all that stuff. So it depends, I guess, is the answer. Hey, Glenn Aladdin. Hi. How are you? Nice to see you. And thank you for joining. So let's see if anybody else has any questions. Let me go to Instagram. Now, Sheikh bin Talib says, how long does it take to get a C9 work permit? Hi, Sheikh. That's a really, really great question. Honestly, if you had asked me this like maybe 3 months ago, I'd told you from 4 months to 10 months, depending on the case type, right? But in the last couple of months, we got work permits in less than a month. And I'm not sure what's going on, but it's good. And so I'm not going to question it, but it's not happening with every case. I know that USCIS is really making a concerted effort to push out the work permits because it was taking too long, and people need to work so that they can take care of their families. So they've actually, in most cases, split the process of getting the work permit and the travel permit into different processes. So sometimes we're getting the work permit first, and then we're getting the travel permit much later. In the past, it used to be together in one card, but now we get the work permit first because they're trying to push the work permits to get to people who need it faster, and then we get the travel permit. So I would really say that honestly, it's all over the place. But if you go to the USCIS case processing website, it will tell you how long you should expect on an average for your work permit. Okay, you're welcome, Sheik. All right, Andrew Lopez, what do you say? Andrew Lopez says, how can I stop someone becoming citizen because of marriage fraud? How can you stop someone becoming a citizen because of marriage fraud? So Andrew, I don't understand this question because it's not really an immigration question. Um, how do you stop someone from becoming a citizen? I don't know. Maybe you can call USCIS. I'm not sure. Igbo brother says, while switching to VAWA case, do my end and travel document come earlier than filing VAWA by not switching from 485? Oh, this question is hard to understand. Let me read it again. While switching to VAWA case, okay. I think you mean your EAD. Do my EAD and travel documents come earlier than filing VAWA by not switching from I-485? No. It doesn't make by not switching. Once you file the I-485, right, it's pending. I think what you're trying to say is you might have had an I-130 petition, and then you're trying to switch that case to a VAWA case, and you want your I-485 to be attached to the VAWA. So if your I-485 is already pending from the I-130 you filed, right, and you filed a VAWA petition and request that the I-485 be moved to the VAWA, the I-485 is still on its own trajectory, right? So it's not going to delay it. It's still going forward. When you were supposed to get that work permit from that process is when you're going to get it. So they don't stop it because the I-130 is no longer the case you're going with. They don't stop it because you're requesting that the I-485 just be moved to the VAWA. It just continues to go the way it's supposed to go. All right, I hope that answers the question, Evil Brother. So Zoe says, how long does it take to file for citizenship after your 10 years green card? Spouse petition, how long does it take to file for citizenship? Zoe, you can file for citizenship after 5 years in most cases, and after 3 years, if you got it through, you got your green card through a U.S. citizen, and you're still married to the U.S. citizen. I think that's what you're asking because it's not really clear. How long does it take to file for citizenship after your 10 years green card? So, okay, I think what you're saying is how long, if you have a 10-year green card, which it depends. If you got the green card through your family members, your parents, child from your work, you have to have the green card for 5 years. And then 90 days before the green card expires, you can put in your application for your naturalization. If you're married to a U.S. citizen and you're still married to the U.S. citizen and you're still living with the U.S. citizen, you're eligible to apply for citizenship after 3 years. 90 days before the 3-year expiration of of that green card, you can apply. Okay, Zoe, I hope that answers your question. So let's see what does Dabu says, what dates U visa BFD getting? What date you? I don't understand that question. I know you're talking about bona fide determination from U visas. I don't really know how long it's taking now, but U visas, everything is taking a while. It's taking a while with the U visas. All right, Sasha Lynn says, I appreciate you so much. Thank you for helping me Sashalin, you are welcome. Uh, So, Ramji says, my wife has a final order of removal from asylum case that was denied. BIA was denied in 2003. I'm a U.S. citizen. Can she get her case? Can she reopen her case without any problem? Yes, Ramji, call us. Call us so that we can assist you. We're doing this for a lot of clients. So call my office 973-993-1900. We need to get more information, but we've been reopening cases. There's actually a case law that's really helpful to that. We've been reopening cases, reopening orders of removal orders, and helping people who have qualified relatives. And we're excited to help you. I really get excited for this kind of cases because it's like the last ditch. They've been ordered deported, but they have a U.S. citizen spouse or child, and we can reopen the case and we can get them their green card. So yes, Ramji, call us 973-993-1900. Glenn Aladdin says, how long does it take to get receipt notices from USCIS after submitting your papers to USCIS? It really depends. I'm thinking sometimes we get it after 3 weeks, sometimes we get it after 6 weeks, sometimes we get it after a week. But I would say on an average, it should be about maybe 3 to 6 weeks on an average. Okay. There's a time the VAWA cases were taking a long time, and then it went back to 3 to 6 weeks. All right, guys, let's see. Babe 22 says, how can I schedule an appointment? Bay 22, you can call us at 973-993-1900 to schedule an appointment. Or you can go to my website if you want to self-schedule, www.odolamilaw.com. When you call the office, we have more openings and we're more flexible than the times on the website. Okay, you guys, it was so lovely chit-chatting with you, and I will be back again. All right, so if you found value in this video, please be sure to like, share, and subscribe, and hopefully other people will find value from this. Okay, take care. Bye-bye.